So, Mr. Knox, on reflection over the adjournment, we are slightly worried for you, namely that you indented for 3.5 hours, and your colleague has to deal with the other point, which we shall be interested to hear. So you've got an hour.
Yes, my lord. I spoke briefly to Mr. Keeley, saying I thought I might be in difficulties finishing, or I and my learned friend, Mr. Benjamin, might be in difficulties finishing by 3 o'clock, and we might need until 3:15. I will be as quick as I can.
Well, I mean, if Mr. Keeley is happy with that, I think he may have some demands, but we can probably provide an extra quarter of an hour at some point quite easily.
Yeah. Well, my lords, I hope so, but I will take it, I hope, as quick as I can.
Well, you're doing
you have my basic points in large part, in fact, already. My lords, I've finished with what you might call the June and September 2007 emails. What I say I get out of them, these are all preceding the contract, and what I say I get out of them is the question of requiring or wanting further finance in addition to the loans then under discussion was clearly raised by my clients in the emails, and there are clear references to it. And even if one treats the 75% point as ambiguous, nonetheless it is ambiguous. In other words, is she saying 75% of what you're currently going to offer, or 75% in future? And that was sufficient in my submission to make it incumbent upon GAM, in a discussion about the differences between banks and GAM, to say, by the way, if you are looking to us for further finance, we don't think we're going to be able to do it, and you ought to know that. We're not the same as banks in that respect. That, we say, is the significance of it. My lords, we say if we're right on that, then gives rise to a negligent misstatement case preceding the contract, and also a misrepresentation case under the Act.
Can you just date the conversation about not being identical to banks?
Well, it is. Mrs. Deslauriers, the dates given, Mrs. Deslauriers says it's, I think, just before the June 2007 correspondence, and then just before also the contract itself is entered into in September. And those references are 197, para 11, and 198, 16.
Yeah.
As far as Mr. Ramdean's concerned, I'm not sure if he specifically dates it, except I think it's at page 79, 36, paragraph L. You can see the second sentence. Since the initial meeting when Mrs. Deslauriers expressed the desire to take all her business from Republic Bank and bring it to us, I told her specifically that GAM was not a bank but an asset management company, and some of the main differences were, it's implicit in that it appears to be some point before the contract was made.
And the position is what the judge didn't deal with this point, but the Court of Appeal did, and the Court of Appeal effectively took Mr. Ramdean's evidence.
Well, the Court of Appeal seemed to think that, well, the way the Court of Appeal dealt with it was to say that the judge had preferred Mr. Ramdean's evidence. Now,
but he had in general terms.
Well, yes, but not on this particular point. In my submission, you're familiar with the proposition. It was on a different aspect, and there was different, what you might call, backup material for this than there was for other things, which I'll come to. So, but in any event, it's before the contract is made. Yeah. On either view. And I also submit the context, it's just on the question of reliance and reasonable reliance, the context, even in Mr. Ramdean's cases, a conversation about, I'm thinking of bringing all my business to you. And it's obviously, therefore, a representation which he is intending, or at least is foreseeable to him, will be relied on. It's not just something we said to each other in the pub without thinking about. It's in the context of a serious conversation about moving business. So I submit this is a sufficiently serious representation to be one to be relied on, as we say it was, whichever the representation was. Now, two consequences follow. One is, before the contract, we say we have a claim in misrepresentation under the Act, alternatively negligent misstatement, which has induced us to commit ourselves to this contract rather than some other contract with a lender who would not have suffered from the same restrictions. In consequence, we wouldn't be in this position now. That's pre-contract. Then there's the post-contract position. What about afterwards? Well, there's no representation post-contract. The Misrepresentation Act claim falls away, but the negligent misstatement claim, in my submission, can perfectly well survive because it's a negligent misstatement which has got a continuing effect. A, it has caused us to enter the contract. B, thereafter, it has caused us not to get out of, or not to seek alternative finance when we could have done. That's our case.
But why? Yes, I see. You say what you would have done before the end of 2008.
Yes, or indeed, I'll come to the email specifically where we raise the prospect of going somewhere else.
Yes, but they told you before the end of 2008 that they're not going to lend more, hadn't they?
No, not quite. They told us about the lending limitation problem at the beginning of 2009.
I thought 26th of November was a pretty clear indication.
Yes, that they would want us to pay back in November, yes, but because I think we were asking for a further loan at that point. But, my Lord, my real position is it should have been disclosed in July 2008. I mean, I accept by November, December 2008, you might say, well, what difference would it have made by then? But certainly in July 2008,
but you weren't asking them for a fresh loan. You were saying in November, if you prefer to get paid off, that's fine. I'll be in between financing for a month with the move, etc. And they said they don't want to extend out. Please repay in January. So
my Lord,
you knew then.
This is page 223, sorry, of the record you're reading from.
No, I was reading E144, the emails of the 17th and 26th of November.
Well, my Lord, I don't specifically rely on, forgive me, it's not, I don't want to waste time, if I may put it that way, on the November position, because I accept by November everything might have been too late anyway, as a matter of causation. The real point is the limit should have been mentioned to me in July, or at least any time before you get to November, because then we will be in a correct frame of mind, we will know the true position when we are in discussions with RBTT.
When did you first ask for the additional 6 million?
Well, that was, I think, in the afterwards, in December 2009, towards the end, 2008.
It must be 08.
Yes.
It's sometimes towards the end of 08.
Yes.
So is the working assumption that you would have been approaching any alternative lender at about that time?
No, the assumption is this. We would know, let's say, as from October 2007,
yep.
July 2008, we'd know all the way through what the true position is.
Yes.
Therefore, when it dawns on us we might need additional financing, rather than may need it, then we know, right, well, we're not going to get it off these chaps at GAM, and we have plenty of time to sort ourselves out in 2008. That's the position. That's, if I may say, is the position.
You could have sorted yourself out after the 26th. Surely the 26th, you knew you're going to have to repay this facility. That's Schluss. You should have been busying yourself on your case thereafter with alternatives. Instead, you wait another month and you come back with a request from GAM for 6 million.
I think
doesn't that suggest that there wasn't any alternative finance from other people?
No. My Lord, if I may say, that's a different point for the moment. May I just deal with what you might call the anterior point, namely, what is the effect, the question of reliance post the contract, and what we say about the non-disclosure post-contract and why it matters. But may I come on to what you might call the loss point in a minute? But can I just, first of all, go to page 233 in the record? Sorry, 223 of the record. And this is an email which Mr. Deslauriers writes on the 30th of July. Suggesting that she wants to know what the total payoff would be in October the 2nd. Projects continuing, however, after that. So she's got some questions.
Sorry, which page, please?
223, sorry.
223, yes, thank you.
So she's raising the question of paying off, then, in October. But then she continues, can I pay down the loan on October the 2nd? So let's say I pay 8 million down, 21 million is 75% of your present equity of 28 million. Can I then begin to make draws to continue the project of up to 10 million, pay off April the 2nd? Now, so in other words, what she's saying is, can I draw up to 20.6 million? That's plainly the premise of the question. If I pay off the entire amount, the land's clear, do you want to finance the balance of the project, and can I still pay off what I use, and so on? So in other words, she's saying, well, let me know what you want to do. Do you want to finance it or not? I have to start thinking ahead. Wants to know if you want to continue with the financing or not. Let me know, as I know you operate different to a bank, and with a bank I can just pay down the loan and keep drawing up to the 75% limit. Now, what I suggest from that is that she's plainly operating on the assumption she's got a 75% limit. As things stand, she can go to 20.6 million if she paid down some and then wanted to carry on and draw out later. And the real point I make on this, there's a dispute as to what happened after this. But I say it doesn't really matter. At this point, GAM should say, look, there's no way we can lend you any more. Then, if that had happened, then she, when she goes, as no doubt she does, she goes to RBTT, she knows the score. Namely, she's got to go to RBTT rather than has an option of coming back to GAM. And so our criticism is that we're not told at this point that there's no way there can be any such increase or further financing. And then at the top of the page...
They're not, the answer isn't actually focusing on the difference between 18.6 and 20.6 million.
No.
Indeed, if anything, it's slightly inconsistent with an agreement to consider more, because it simply says all you'll be doing is Duke of York stuff, paying down and then getting out again.
My Lord, I fully accept it's inconsistent with an agreement, but I'm not on that point.
No.
I'm on the point, I accept that, obviously. It's
Yes.
totally inconsistent with there being an agreement. But what it is consistent with is an understanding that she can borrow more if need be, and that GAM is in a position to do so. And she's asking GAM, well, what's the score? Now, GAM say, I'll have someone to call you, remember you've got this facility. But the one thing they don't say is, look, there's no way we can lend you anymore. So my criticism is that the statement continues to operate on the appellant's minds. They think they can get more, and they obviously do think they can get more, and they're not being told they can't. And this is at a stage when, realistically, they could. And that's really the strength of it.
So they should have said, sorry, the whole premise, not only do we think it's a stupid idea, but the whole premise is false insofar as you're suggesting you might in some way get up to 20.8 million by paying 8 million down and then drawing 10 million out. Yeah.
You're barking up the wrong tree, and also if you think we're going to give you any more financing, you're barking up the wrong tree.
This failure to say that is it in a Headley-Byrne claim in tort.
Yes. Yes. In other words, the representation is continuing.
So your lender owes you a duty to look after your interests.
Well, if he's already said there are no differences between him and the bank, if I've already said that, let's say last year, and there I am, I remained under a duty at that point to say, well, now you ask me that. No. I've already told you one thing which is wrong, and I'm now still continuing to believe it. And when the opportunity comes to correct, it's not taken. Now, my lords, if one goes over the page to 226, or a couple of pages, to 226, you'll see Mrs. Deslauriers is writing, basically saying, she's gone to RBTT. Halfway down the page. And, my lords, in answer to the question, what were RBBT prepared to do, you'll see she's saying 5 lines down, they would really like to finance the project for the last 10 months. Now, that doesn't just mean, replace the loan. That means finance the project. I guess you went up that day, and so on. And she continues what the value of the project is. Now, what we say is there is plainly a case which was not challenged in cross-examination to the effect that, well, she was talking to RBTT, she's doing it under a misapprehension that she can go back to GAM, and she can't.
Well, she isn't doing it under a misapprehension. She can go back to them. She's completely uncertain whether they are interested.
She's uncertain, but the door hasn't been closed when it should have been. That's what it comes down to. And had she known there was a closed door, then she would have stuck with RBTT for all their faults, slowness, whatever it was. At least she knows.
Well, she was told very quickly after the 19th, wasn't she, on the 26th, that they wanted it paid off, so they were not interested in anything more.
Well, by that stage, yes. By that stage, yes. But she wouldn't be in this, what you might call, whole pickle. And, my lord, I think the email, forgive me, my lord, you had referred to the email where GAM write back saying no.
Yes, that's
You'll
144.
See, sorry?
144.
1444. 144. And this is 26th of November. Well, my lord, he's not actually saying, even here, if I may respectfully say, we can't do it. I would have to extend the existing facility out to another year, 144, together with requested additional facility. Therefore, would I have to accept the facility? He's not saying, well, we've got a lending problem. He seems to be saying, well, the trouble is, I'd need to have the facility repaid now, in January.
He's talking, you say, about the mechanics of it.
Yes. He's not actually saying there's no way we can lend you that money.
Yeah.
So she's not being, even then at this point, corrected. Correction comes in for the first time in January 2009. After all, my lords, she asked for the 6 million in December 2008. I mean, just as a matter of common sense, she's unlikely to have been told there was no way it could be lent before she's asked for it. So, my lords, but the real position I maintain is it would, and certainly one cannot at this say there was no basis for an inquiry into whether she could, on an assessment of damages, could have got the further financing had she known the truth. In her cases, she would have stuck with RBTT. I accept there's no evidence from RBTT as to what their position was. So, my lord, that's what we say in relation to the reliance point on the post-contract negligent misstatement, or rather, the operation of the negligent misstatement post-contract. My lords, can I just deal briefly with a point that featured prominently in the Court of Appeal's judgment against us on this issue of should GAM have realised that we might want further finance? Because what they said is the judge found that the Deslauriers had said that money was being sourced elsewhere. Money was being sourced elsewhere. And that you get at the judge's judgment, paragraph 39 at 429, and page 434 at 51. The judge makes findings, albeit in relation to a different part of the case, it doesn't really matter for the moment, that we had said the money was being sourced elsewhere. And the Court of Appeal placed quite a lot of reliance on that. Page 753, para 28, 754 to 5, para 36, and 757 at 40. And that features prominently in the findings against us. But in my respectful submission, that is plainly a bad point. First of all, in the judge's judgment, he does not refer to when, he doesn't make a finding, rather, as to when that statement is said to have been made. And that's quite important, because there's no doubt that afterwards we did say that we were looking to finance elsewhere. But the real point in my submission is that when you look at Mr. Ramdeen's evidence on this, which is at page 79, 36H, he doesn't actually identify when the statement was made, page 79. Just to set it in context, one can see at G at the top of the page, he says there was no discussion on additional financing. But then H, Mrs. Deslauriers also told me that if the funds from the sales didn't cover the additional financing, her intention was to get that financing elsewhere. So it's actually just an expression of intention. When...
That's clearly pre-contract.
Well,
no?
Well, my lords, maybe.
At the
maybe.
time, GAM discussed the possibility of the loan.
Well, that's G, but H doesn't have that as a precedent. But my lords, she's cross-examined on when did this take place? And that, my lord, you can see at 355, about 3/4 of the way down the page. 355.
Thank you.
And he's pressed on, well, near the foot of the page. He's pressed on when this discussion took place. The question, can't tell you the exact date, time and hour. And my lords, I submit it's unsatisfactory in those circumstances to say, well, he must have made it, this must have been something said to him beforehand. But my lords, more importantly...
Well, did the judge find that? I mean, the judge had presumably a fuller recollection than these rather short notes.
Oh, my lord, I don't know if these are mere short notes, my lord. I'm told, actually, they are typings up. As you can see from the precise timings you see. In other words, they're not just transcripts of the judge's handwritten notes.
But typings up of what?
Sorry?
Typings up of what?
Sorry?
What are they typing?
So recording. No, he wasn't, no. So, my lord, what you see here is the word for word, except those bits have been omitted, like speeches and things. But, my lord, there are 2 points. First is, Mr. Ramsden is not able to date when this is said, but also, secondly, he says this is what her intention was. And, my lord, there's one thing to say, this is my intention. It's quite another thing to say, I am already getting the money from elsewhere. And the mere expression of an intention is not inconsistent with prospect, which I submit is apparent from the correspondence, that she might come back for further financing later. So what if it's my intention? Doesn't mean I'm going to be able to perform it. So I submit it's not a good point to say that the misrepresentation claim is knocked out by that point. And in my respectful submission, when the judge says at paragraph 39, if I may go to page 429, Para 39, you'll see how the judge translates intention to fact. The court accepted the evidence that he had been told that the balance of the budget was being funded. My lords, I submit that just wasn't his evidence. So it's doubly wrong, A, because it presupposes this is pre-contract, B, because it translates intention into fact. My lord, there's another point on this, and that is, it is inconsistent with GAM's own case as to how it was pleaded. Certainly the finding is, if you look at page 52 of the record, you can see how GAM put this point. And I submit that we don't take particular issue with this in general terms. Page 52, paragraph 7. The claimant denies paragraph 14 about discussions. At all material times, the defendants represented the claimant. The defendant confidently expected to have the Heveron Heights project completely sold out before 1 year and confidently expected to be in a position to repay the entire balance and so on. And then paragraph 8, to similar effect, claimant admits paragraph 15 of the defence and so on. Insofar as the defendants informed the claimant that the source of funds for repayment of the loan would be deposits and proceeds of sale. Well, there's never been any issue on that. Claimant says that at all material times, the defendants represented to the claimant that given the rate at which units in the defendant were being sold, the defendants confidently expected that all units would be fully sold out before the end of the period and would be in a position to repay. That is all that they pleaded. And I submit, therefore, that finding is simply inconsistent with GAM's own pleaded case, not borne out by the evidence. My lords, that takes me to the end of what you might call the the significance of the failure to mention the limits. My Lords, I hope I can take the other parts of the case relatively quickly, because I've shown you, I think, most of the material. The next question is did the failure to mention the limits falsify the representation as to the difference between GAM and the banks? Now, my Lords, we've had some conversation about that already this morning. I've given you the references for the competing versions. Just for your note, 197, paragraph 11, 198, paragraph 16, for my client's version, and Mr. Ramdeen's page 79, paragraph 36L. My Lords, we say, first of all, it doesn't matter whose version you prefer. Where you are close to your lending limit, and there is a conversation between you and your customer about differences between yourself and a bank, it was, in my submission, misleading not to mention a very important difference, namely, by the way, I'm not going to be able to lend you that additional financing, or at least very much of it, that you think you might want to ask me for. I submit it doesn't matter which representation was made. But secondly, insofar as it does, I say the court should prefer the appellant's version for the following reasons. First, the judge himself makes no finding, plainly makes no finding on the point. He does, in his recitation of the evidence, refer to the representation at para 32, at page 427, but he doesn't make anything of it after that. The Court of Appeal, as I mentioned a moment ago, rather suggests that he did make a finding. That's paragraph 24, page 751. And I say...
Paragraph 24.
24, page 751, Court of Appeal. We set out in paragraph 60 of our case why the court should prefer our version, so far as it's necessary to do so. The reference is page 855 of the electronic bundle. My Lords, first of all, we rely on the pleadings. We say we pleaded our case clearly. Paragraph 16 and 20, page 43 and 44. I've taken to them already. In the reply, you get a rather equivocal reply, but it certainly doesn't set up the representation contended for by Mr. Ramdeen. That's at page 53, paragraph 9.
Sorry, page
53, paragraph 9. There's no express averment in the reply as to what they say the representation was in relation to differences between banks and GAM. Secondly, my Lords, the contemporary evidence of the complaints. On the 23rd of April 2009, I think I showed you this letter at page 69 to 70, we expressly set out what we said the representation was. We complained about the phrase the only difference was used. In GAM's considered reply, not an email reply, on the 11th of May 2009, which I took you to earlier in a different context, page 176, they don't deny the representation. I think I said 11th of May. It may be actually on the 18th of May, 2009, page 182. Forgive me. I think I may have misled you, my Lords, as to precisely what happened. Forgive me. It's the letter, page 176 is a further letter of complaint by Mrs. Deslauriers on the 11th of May. That's when she sets it out. Sets out her allegations.
Which is the page where they...
176, and I think it's at
Yeah, no, I've got that, but which is the page where they failed to challenge?
182. It's the 18th of May, 2009.
Well,
Doesn't address the conversation at all, does it?
No, no. The relevant bit on the 11th of May email is the first paragraph. You told us the only difference.
Yeah.
So, my lords, you've got contemporary, as it were, allegation faced with just a non-answer. Now, the other point I rely on is this. Mrs. Deslauriers was not challenged on this, her version of the conversation, in cross-examination. She simply wasn't challenged. I accept the same could be said that she didn't challenge Mr. Ramdeen. But there was, in my submission, a difference. It's perhaps understandable as a litigant in person, not least, my lords, because the judge, when... I don't, my lords, it's understandable how these things happen. The judge, when telling Mrs. Deslauriers how to conduct cross-examination, does say, if you turn to page 336, doesn't really make it plain to her what exactly the rules of the game are in relation to serious allegations. And you'll see that in 336, about three-quarters of the way down the page. He says, you're permitted to suggest the witness matters which form part of your case, and so on. But, my lords, if the point's to be taken against my clients that they didn't cross-examine when they should have done, they reply, well, it wasn't as plain to them as it should have been to counsel. So, my lords, that's why we say, insofar as the point matters, you should find in favour of our version. My lords, that's what I say about why the representation was falsified, whichever version is to be preferred. My lords, as to reliance, if I can deal with that fairly briefly, because I've already gone through, I've taken you some of the evidence, we say there are two ways in which there was reliance. One is the pre-contract reliance going to GAM rather than someone else. And I've taken you to the passages, paras 13 and 15 of the Mrs. Deslauriers statement, page 198, 199. Secondly, there's the post-contract reliance, that she doesn't pursue her opportunities with RBTT, and that, you see, and I've taken to that, I think it's paragraph 22, page 201. Now, my lords, her evidence as to that reliance, again, simply wasn't challenged. It was not put to Mrs. Deslauriers, oh, come on, you didn't believe all that stuff about lending limits, or that didn't operate on your mind at all, or you would have gone to GAM anyway. No, there's nothing like that at all. And, my lords, the judge himself makes no finding. Perhaps understandably, because he just rejects the case anyway. But the Court of Appeal says, in paragraph 28, page 753, that he did make a finding. In my submission, they appear to say that. That's just wrong. He didn't. But in my submission, it just wasn't open. It's not open to the court now to make a finding of non-reliance, given that my client's evidence wasn't challenged in cross-examination.
Well, they didn't. Did she say that? Well, I think we're going over old territory, perhaps. But did she actually say that Republic Bank would have lent on a basis which would enable her to draw down whatever she needed to complete the project?
Not in her witness statement, no. But, I mean, the whole thrust of what she... my lords, that in a sense might go more to the question of loss rather than reliance. But it's always been her case, both in the correspondence and witness statement, that she was led to do what she did by virtue of her belief as to the lending limits. But there is the separate question of loss.
But she's got to show, yes, I see your point. You say it goes to loss, but she has to show that she's worse off by moving to the claimant.
Or potentially worse off.
Yeah.
Yes. I accept that, my lords. But, my lords, but that point, there are two separate points. What did I do in reliance? Second, what would have happened otherwise? There's no cross-examination on the first point at all. No challenge. And that has to be some conscious decision. Well, either that or what's going on, I don't know. Now, my lords, as far as the question of loss is concerned, so I say, on the question of reliance, my client's evidence has to be accepted, if you're with me on misrepresentation. The question then arises about loss, what to do about that. Now, my lords, I accept that the trial was not a split trial. There was no order for that. However, That said, I submit a perfectly proper case management decision, which one has in many cases where a court finds that actually there has been a misrepresentation, but it's not satisfied as to the position on loss, because, of course, one never quite knows what findings on liability a court might make. The court often says, right, well, I'm satisfied there was a misrepresentation. I will now order an assessment of damages. And I submit that's what the court should have done below. If the judge had found with me, I say that's what he should have done. And likewise, I say that's what should happen now. In the Court of Appeal, that was what we suggested should happen. And there was simply no contrary argument. It was never suggested. Actually, really, the whole question of loss was hopeless anyway. And I do submit, to the extent the Court of Appeal made findings to that effect, it should not have done so. First, just dealing with the merits generally. It is a reasonable inference. It wouldn't be a fanciful, if I can put it this way, it wouldn't be a fanciful inquiry to have an assessment of damages to take into account the question whether or not my clients could have found an alternative lender, both before the contract and indeed after the contract. There's no reason to, and the reason I say this is because there's no suggestion this was a dud project, or they were asking for too much money, or that this sort of financing isn't available. Far from it. So there's a real prospect of my clients being able to prove a chance. Secondly, I submit you do have, anyway, the evidence I've referred to about the conversations with RBTT in 2008. There's real material to go on. So it would be proper for the court to order an assessment of damages. Now, as far as the Court of Appeal's findings are concerned, I submit the first point the court takes is that no loss was pleaded. Well, my lords, I've dealt with that. I've said it was. You may or may not think that's an optimistic pleading, but it was dealt with, and evidence was given about the losses and so forth sustained. That would be on the premise alternative financing could have been found. So I submit loss was certainly pleaded, and there was evidence, you might say a bit optimistic, but there was evidence as to the inconvenience to which this had put my clients. My lords, the pleadings are 47 to page 47 to 48, paras 36 to 37. I've shown you them before. My lords, the second point I make is this. The judge hasn't made any findings on loss. Third, at least in the misrepresentation claim, on the face of the authorities at the moment, you have the Roy Scott and Rogerson case about Section 2 of the Misrepresentation Act. You adopt the fiction of fraud in assessing damages. Now, that may or may not be, there's academic commentary as to whether that's really right, but at the moment, that's how things stand. So for that reason, too, you send this matter back for an assessment of damages. It doesn't matter, let us say, that no one expected the market to crash, and that may have been a contributing factor. But even so, I submit, even forget the Misrepresentation Act, the mere fact, it's when you're entering into a contract with a lender and to finance something, one of the reasons you do it is because not just they're there for the immediate money, but you think they're there, or maybe there, for the long-term future. If you're misled about that, I submit you're perfectly entitled to say, I thought you were with me for the long-term future. Now turns out that you were never going to be. I lost the opportunity of getting someone who would have been in there for the long-term future. Therefore, I should be entitled to damages to compensate me for that loss. And to say that you should somehow lose on some sort of Bank Bruxelles basis or basis like that, I submit couldn't possibly hive the matter off like that at this stage.
Your first point was that remoteness doesn't enter into it. Is that right?
Under the Misrepresentation Act.
Because of
the fiction of fraud.
Right, anyway. Fiction of fraud, which
query remoteness, or at least you don't have foreseeability entering into it under the fiction of fraud.
Yes.
And you may have different remoteness rules as well.
I mean, that's just English authority at what level?
Court of Appeal.
Yes. And
it's stood for the last 30 years. There's been comment on it.
We might want to think about that if it became...
I don't know. Well, my lords, I'm running out of time. I'd love to address you on that, but... But no. But my lords, we say that is certainly the current understanding, unless there's been a recent decision which I'm unaware of. That's the current understanding in... now, my lords, so that's why we say the matter has to go in any event for an assessment of damages if we're right on liability. My lord, very briefly, we've got the unfair trial point. Now, it's not a self-standing ground of appeal, but we do say They're repeated. We refer to this in our case. We refer to the repeated interjections by the judge, next question, next question. And the impact of that is really to say to the to Mrs. Deslauriers, right, you've asked that question, you've now got to move off to another subject, rather than you can ask another question on the same subject. And I submit that would give that impression to anyone, actually, even if it was counsel, but certainly to a layman. And I do submit it does therefore make it inappropriate to treat, if I can put it this way, findings based on credit of Mr. Ramdeen as against Mrs. Deslauriers not as cast iron, as would normally be the case on an appeal. The court must approach with some caution, in other words, findings to the effect that the judge found so-and-so in favour of Mr. Ramdeen, therefore you should take it either A, that finding was necessarily correct, but more importantly, B, he found everything else, or would have found everything else in his favour. It's the B that really matters. And my lords, I've given examples, A, of general next question, and also refusal to allow cross-examination to take place on the pleadings. We're perfectly entitled to cross-examine on pleadings. The client might eventually say, oh, I suppose you're probably right. It was not suggested that anyone else except Mr. Ramdeen could possibly have given instructions for the pleadings. Mr. Sancerre had left by that time. So, my lords, that's what I say in relation to unfair trial. I shall now, unless the subject of any further questions, my lords, hand over to Mr. Benjamin for the Victoria Square appeal.
Thank you very much. Yes, Mr. Benjamin.
My lords. My lord, I'm not entirely certain how much time I have, or how much time you'll permit me, but I'll do the best I can in the time that you indicate.
Yes, you put in a very clear and helpful case, so we can probably take some of the points, but there are some authorities which will need consideration at some point.
Yes.
The first point is quite an important one. Generally, there appears to be, there is another Trinidad and Tobago authority on it, isn't there? I think it's cited in the respondent's case. I think it comes from TNT.
My lord has Bawani in mind, Bawani and Guppy, a decision of Mr. Justice Abood. Is that the decision, my lord?
I think that probably is the one, yes.
Yes.
Anyway, take it as you can. I mean, there are several separate points. But
yes, my lord. Yeah.
Obviously, you'll take it in the same order, I imagine.
My lord, in formal terms, this appeal, the Victoria Square appeal, against the order of Mr. Justice Rahim and affirmed by the Court of Appeal, has to do with the direction or order that he gave for the sale of Mrs. Deslauriers' alleged beneficial interest in Victoria Square. We respectfully submit, however, that the substance of the appeal is about the order in which GAM accesses her assets in order to discharge her debts, and, of course, the nature and extent of those assets that are available for the purpose of discharging that debt. In other words, it's about what is the extent of the beneficial interest. Is it a life interest or is it something greater? That's one. And secondly, what is the correct timing or sequence in respect of which GAM should have access to the two real estate assets that are the subject of the appeal, i.e., our argument has been before Justice Rahim and similarly in the Court of Appeal, that GAM should proceed against the Heaven Heights property and should do so in priority for a couple of reasons. The first is that that would be the way in which the entirety of the debt could be discharged, whereas to do the opposite, even on GAM's evidence, is to ensure that the entirety of the debt could not be discharged or paid off.
Just the second point only arises, really, doesn't it, if you're wrong on the first point? Because if you're wrong, if you're right on the first point, then, as you said a moment ago, there's only a life interest,
yes,
is all she has, and that wasn't what was ordered to be sold, if indeed you can sell a life interest sensibly.
That's right, yes. I accept
the judge ordered the property to be sold. So I mean, just jumping ahead to that question, one practical problem that arises is that there has been years in which your clients could have sold this property. How long as a creditor to wait? I mean, do you say it'll be very easy for them to sell if they get an order for sale of Heaven Heights, and that will anyway crystallize things?
Well,
You've had years of opportunity to sell it if it's saleable.
Yes. So, my Lord, but can I answer both of my Lord's questions? In answer to the first question, what the evidence discloses is that what we were seeking to do was to get alternative investors. In other words, we were talking with construction people and other investors to come into the property with us, either on our own or alternatively, we were inviting GAM or other financial institutions to do the same. Yeah. So that what we were seeking to do was not a straightforward sale. So, to answer my Lord's second question.
But you think it isn't really saleable unless you actually complete it?
No. I'm simply saying that's when we, at each stage, for instance, when Mrs. Deslauriers approached the Court of Appeal in 2012, you will see the detail of the evidence that was put before the court did not concern anything other than the efforts that she had made to enter into a variety of arrangements for the purpose of continuing the project.
Yes, I understand that.
Yes, my Lord, sorry.
You're saying that she's not been trying to sell it, but the question is, why not?
Well, my Lord, I'm not saying that she hasn't been trying to sell it. I'm saying positively what it is she has been trying to do. Yes. And to answer my Lord's second question, I think, which has to do with whether or not it would be a property that would be sellable by GAM, my Lord, when I take you to the evidence, you will see that in spite of the fact that Guardian Asset Management, A, filed its fixed date claim form, B, got its possession order, C, had the entitlement to seek valuations, on two separate occasions, both Mr. Brentford as CEO and Mr. Ramdeed as the Vice President declined to take the step, i.e., to seek a valuation prior to sale. In other words, they expressed no interest in taking that step at all. And that, we would say, would be inconsistent with, A, the steps that they took to get an order in the first place, and B, contrary to the reasonable expectations of the parties to the whole contractual arrangement. So our core submission, as far as that's concerned, is that the property is the first, as it were, source or resource to which either party should have regard to, and that was agreed to by virtue of the contractual arrangements, and much more specifically, the mortgage.
Well, wait a minute, that's not agreed. I mean, you've got promissory notes here.
Yes.
If there's a debt on the promissory notes,
yes,
they don't have to look to the mortgage to satisfy that. They can look to anything.
Well, my Lord, our respectful submission is that one has to look at the transaction in a composite manner. In other words, it's not a question.
But promissory notes are independent of the transaction, aren't they? They're an obligation to pay, which...
Yes, they are.
The very most you could say is that if there's some discretion to stay execution of a judgment on the promissory notes, that might be exercised. But anyway.
My Lord, with respect, I'm not on the issue of proof or stay, i.e., I mean, the primary purpose of asking a borrower to enter into a promissory note would be for ease of proof of the liability. In other words, you can seek summary judgment, you don't have to have a trial, there are very limited defenses, in very limited circumstances, you can seek to stay execution on the judgment on the promissory note and have as my little friend Mr. Knox has already suggested to you, have an assessment of any cross-claim, as it were. But Lord, I'm not on that. I am on taking the transaction
as a whole.
as a whole. There could be no doubt, well, my respectful submission is that when one looks at the transaction entered into between the parties, that the parties agreed and their conduct in the course of their relationship is entirely consistent with treating Hebron Heights as the primary source of A, security when the contract was ongoing, and B, as a source from which the debt would be repaid in the event that the...
contemplated. Are you saying that it creates a duty to look to Hebron Heights first?
Absolutely. Yes, my Lord, I am.
By what route does it do that?
My Lord, I say with respect that it arises from the reasonable expectations of the party to the contractual arrangements, and that includes A, the promissory note, and B, the mortgage.
So really it's a question of evoking the court's discretion, is it? Assuming there is a discretion. And you say, you made some criticisms of GAM in this connection, but failing to take a valuation, but they haven't been in a position where they could sell, have they, until now, because of the ongoing proceedings. So that I don't know what the evidence is on this, but it may be they've taken the view that until they actually have the right to sell the property, there's no point in getting a valuation of it. You're in charge. You could arrange a sale or propose a sale.
Yes, my Lord. And we did take some steps towards that. To answer my Lord's question directly, what I'm saying is I'm criticizing, insofar as that's an appropriate way of characterizing it, I'm criticizing their lack of action. In other words, prior to the judge making the order for possession, which if you look at, if I can invite your attention to the supplementary bundle in the main appeal, and it's electronic numbering 2396. It's a thin bundle that my Mr. Knox drew your attention to. If I can invite your attention to, first of all, the fixed date claim form.
Yes. Fixed date mortgage claim, yep.
Yes, the fixed date claim form. And my Lord will see, by reference to the relief that's sought there, it's a straightforward claim for the delivery of a vacant possession. And my Lord, that would be an act consistent with an intention to effect a sale.
Yep.
And my Lord, for what it's worth, the actual arriving at that order was unopposed by Mrs. Deslauriers. And insofar as my Lord's, my thing that I'm trying to draw an inference, can I invite your attention to the affidavit of Mr. A.V.?
Right.
And at the very end, paragraph 22, page 2410, my Lords will see that Mr. Avery deposes on behalf of GAM that it was the claimant's desire, pursuant to its power of sale under the deed of mortgage, to offer the mortgage property for sale with vacant possession on the open market. And that is the reason and the basis for seeking the order.
Right. Right, I see. So you say it's under the mortgage, yeah?
Yes. And my Lord, I'm also saying that as I also drew my Lord's attention, I'm going slightly out of order, but I wanted to at least give my Lord the references that Mr. Ford, in an affidavit dated the 7th of May, 2014, and Mr. Ramdean, in an affidavit dated the 23rd of June, 2014, as well as the 7th of May, 2014,
Yes.
also evince their intention on behalf of GAM to seek a valuation. So as far as the first reference is concerned, Mr. Ford, that's electronic bundle, page 209, paragraph 13. Now, this is as of May 2018. And what he says, as at that date, if my Lords have it, I have retained valuators to provide the claimant with an opinion on the value of the project, meaning Hebron Heights. However, since the claimant creditor does not have possession of the premises, I have not been able to secure the valuation, and I would need to have that done to determine the current market value of the project.
So that's why he's seeking possession.
Oh, absolutely, my Lord.
Yes, right.
And we put this in our written case. Shortly after that, there was an appearance before Justice Rahim on or around the 13th to the 14th of May, in respect of which he gave an order that GAM be permitted to file evidence in respect to valuation, And that was on the basis that, that Mrs. Deslauriers would cooperate. So if I can invite your attention to the parallel paragraph in Mr. Ramdeen's affidavit, that's electronic bundle, page number 214 at paragraph 12. You will see there that he too says, and of course this is in the context of disputing the current market value, but I'll come to that shortly,
Yes.
that he wouldn't be able to obtain, that they wouldn't be able to determine the value until they got possession of the premises.
Right.
So, my Lord, just pausing there and just taking stock so that we know that after, in the start of the new term, this end of September, they obtain an order for vacant possession, but they take no steps to seek their own valuation.
So when's the order for vacant possession?
It's the 29th of September 2014. And you know that is correct because throughout the affidavit material, and it's relied upon on what I call under the heading of valuations, my lords will recall that while they quarrel with and take issue with the February 2014 valuation of Heaven Heights in the sum of $77 million, at no stage now or thereafter do they adduce their own professional valuation,
Right.
even though they had an opportunity so to do. And putting it at its lowest, they certainly had an opportunity so to do since the 29th of September 2014.
Where's the order of the 29th of September?
The order of the 29th of September is found at Lord, it's to be found in volume 2. So I was looking at the wrong volume. It's volume 2 of the Record of Appeal. It's electronic page numbering 467. It's exhibit FAR 6 to the affidavit of Mr. Faris Alwari.
Right.
And my lords will see there.
Oh, wait a minute, there'll be a stay of execution for 90 days. Has that been lifted or expired? It hasn't been continued.
It has been continued, my lord.
What?
It has been continued.
Has.
Because we made an application.
So, so they haven't had possession yet?
We made an
haven't
application.
had possession?
No, they haven't had possession. But I wasn't on that, my lord. I was respectfully submitting that they had an opportunity to obtain a valuation pursuant to their order of possession, and they did not take that opportunity.
Well, how come if they don't have possession or right, were they given access?
Yes, my lord, that was the point that I was making earlier. I was saying that even before the order was made, there was an order for them that permitted them to file affidavit evidence in respect to valuation.
Yes, but was there an order at some point, or if not an order, an agreement, giving them free access to the property with their valuers to go around, poke wherever they wanted to, make all the inspections they needed to, and so on?
Yes, my lord, that's what I was submitting.
How was that done?
My lord, when the parties appeared before Justice Rahim, I apologize, the GAM made the very same complaint that they didn't know what the position of the value of the property was, and an order was directed so that they were allowed to adduce that valuation evidence.
Well, where is that order, by the way?
Lord, we don't have the order. The order was not written up, but what I would like to tell you...
you're giving oral evidence about something which is contrary to the reference you gave us at page 214, where they were complaining that without possession they couldn't get a valuation. Now you say the judge nonetheless solved all that, and very sensibly if he did, but where is it?
My Lord, the order was not written up. What I would like to invite your attention to is the affidavit of Mr. Ramdeen,
Yes.
which comes subsequent to that.
Right, yes.
It's the 23rd of June, 2014.
And this might be seen to be a fairly marginal point. Here you are blaming GAM for not having a valuation. What might be thought to matter just as much is that you haven't produced a viable buyer. You've been in possession at all times and have had that opportunity for years. You say it's very valuable, you've got large debts, you say people should look to this primarily, and so on. I mean, you're on discretion, and if it arises, if it exists, just take what you say about the judge's order. You can give us a reference later rather than spend more time. But we've probably got most of the factors on discretion. There are some quite hard points of law before we get to discretion, aren't there?
Yeah, my Lord, my initial comments were meant to be by way of opening.
Right.
My Lord, can I just to close off in answer to what my Lord just said?
Yeah.
My Lord, we say that when the evidence is looked at, that there were clear expressions of interest, A, that they were communicated to GAM, C, that while they were in amounts that were below the valuation figure of 77 million, they were all in excess of the amount of the debt at the time.
Yes.
And that D, in any event, as I've already submitted to my Lords, a sale of Victoria Square wouldn't come anywhere near to meeting the principal of the debt, let alone interest. My Lord mentioned the question of discretion. Can I just put that to one side and really try to assist my Lord in relation to the trust point? Can I do that first?
Just one final point. The
Yes.
stay of execution
Yes.
of the order for possession was given presumably because of the proceedings challenging the whole question whether there was a debt.
Absolutely, my Lord, yes. So that the premise of the application for the stay was on the basis that there had already been an appeal filed in relation to the substantive matter, the main appeal. Right. That's one, and just as a matter of chronology, it was due to come up for hearing within 6 months, so that at the time that the learned judge was granting the stays, in fact he granted two, in relation to both orders, they were both in September and October of 2014, and the appeal were due to be heard in May of the following year. In fact, both appeals were heard within a very short compass of time. So it was really the proximity and time of the substantive appeal that led to, on a consensual basis, as it were, in relation to the stay. I trust that provides my Lord with some assistance. My Lords, the first issue that I would like to address, and as is set out in our written case, has to do with the effect of the deed of settlement entered into by Mrs. Deslauriers. And as my Lords would have seen from the papers and our written case and the case of the respondents, it's a deed of settlement dated the 8th of December 2009. its salient parts are reproduced in the record. You will find them at, you will find the substance of it at electronic page numbering 132 and onwards. And both of the respondents reproduce elements of it in their written case.
Yeah. It's what you make of the recitals, really, isn't it?
My Lord, that is really where the parties join issue. That is to say, you have competing theories advanced on by the respective parties as to the impact of the recitals. Yeah. That is to say, and in particular, if I can focus my Lord's attention, as you already have done, in particular, recitals 4 and 5. So can I look at those very quickly, but precede that or preface it by making the unequivocal submission that, of course, they are to be read in light of the operative provisions of the deed of settlement, and specifically, and I'd like to go to that first, specifically, that the trustee shall hold the trust property upon trust to retain the same in its present state of investment, and shall, with the consent of the settler during her lifetime, invest the income from the same and any other monies from time to time requiring to be invested under the provisions of the deed. So I'll stop there. That's clause 1. And clause 2.
Yeah.
And clause 2, that the trustee shall hold the trust property, the trust investments upon the following trust, and the two trusts are identified. So that I would invite my lords to construe recitals 4 and 5 with particular attention to the word, the present state of investment. Because as I understand the case being advanced by the respondents, it is to the effect that this trust arrangement really existed in the future upon the conveyance of the legal title. And I would respectfully submit that that is not a fair, nor accurate, nor thorough reading of the deed as a whole, but with particular reliance upon the substantive provisions. So, my Lord, with that introduction, can I invite my Lord's attention to the two recitals that are relied upon? I suppose it's fair to say that they go in different directions. And the directions both have to do with time. One says, we say, it's an existing settlement. The respondents again say that and say it only takes place sometime in the future. The respondents rely upon recital number 4, that's page 132. The settler intends shortly to transfer the trust property into the names of the trustees to be held by the trustees upon the trust hereinafter declared. The next recital is 5. The settler desires that the settlement made by this deed shall take effect immediately upon the execution of this deed. So we say with respect that there is unequivocal language which points towards the present, and that if you take 4, 5, as well as the operative provisions together, our respectful submission is that the arrangement under the deed of settlement comes into existence upon its execution. And it's quite important, we say with respect, that it is executed by, as it were, all the parties. The settler executes it, as well as the proposed trustees. And that's
how does it take effect in law? How do you just express it?
So it takes effect in law by way...
Yes.
Sorry, my Lord.
No, go on.
It takes effect in law by way of a transfer of the beneficial or equitable interest in Victoria Square. And we say that that follows from two clear and unequivocal statements. We say it follows from the face of the operative provisions, that is what is being expressly contemplated and acted upon, i.e. operative clauses 1 and 2. And we say further that is the separation of the legal and equitable title follows from the settler's express intention, and I quote, shortly to transfer the trust property into the names of the trustees.
So effectively, it's a declaration, is it, of trust by the settler in favour of the trustees, is it?
My Lord, that would be my fallback position, but it's not my primary position.
So what's the primary?
My primary position is that there's a transfer of the beneficial or equitable interest.
Well, isn't that the same?
No, my Lord, with respect.
How can you transfer the beneficial or equitable interest without declaring a trust in favour of the beneficiary?
Well, my Lord, with great respect, there is more than one way to to effect a trust, my Lord is absolutely right, and the authorities from Milroy and Lord all the way down are entirely consistent with that one way is a declaration of trust. And as I've said to my Lord, that's my fallback position. My primary position is reliant upon the language of the document, which effects a transfer of the equitable and beneficial interest, because it says to the trustees that they are to hold the property on trust against the context of saying, but not the legal title. So that you have clearly on the face of the document, I respectfully submit, properly construed, a clear separation of legal and equitable title. That's intended by the language of the document, because the document does not purport to convey legal title at this stage, and that it equally follows from A, the language, and B, specific words in the operative parts, present, investments, etc., as well as the recital that...
Could I ask you about those words which you say are significant in the second line of Clause 1?
Yes, my lords.
Present state of investment.
Yes.
What do you say we should understand those to mean?
There are two aspects of it. So one is that it's speaking to the current situation as at the date of the execution of the document.
Meaning what?
Meaning, and then the second aspect of it is...
Stop there.
I'm sorry, my lord.
Meaning what?
Yes, sorry. I was trying to answer, my lord.
Oh, right.
I apologize. No, I do apologize. My lord, it seems to me that those words mean the current state of the property, i.e., does it provide a return? So, for instance, we know in this case, the document having been executed, I'm just going to confirm the date, on the 8th of December 2009, that for at least 2 years, by this stage, and this is made out in the Statement of Facts and Issues, this property was, for the most part, tenanted. That is to say, it was occupied by a tenant who was paying rent. So we know that in terms of this property providing, as it were, return on investment, being a source of income, and with the potential perhaps to do other things, but that, of course, is speculation. I don't want to breach any prohibition about giving evidence again, and I apologize for that. But we do know that on the evidence, on the unequivocal evidence, that was the state of this property, that it was an income-producing property, in part.
So to retain it in its present state of use?
Yes.
Right, got it.
But not just use, my lord, in relation to, in terms of what it is producing, as in the return on the investment, i.e. the capital investment that the property represents, with its ability to produce income. I hope I've answered my lord's question.
Thank you very much.
I'm deeply obliged, my lord. And my lord, we say that's further reinforced by what follows at Clause 2. Because the trustees are enjoined in relation, this is my respectful submission, the trustees are enjoined, Mr. David and Ms. Lindsay Deslauriers are enjoined by Clause 2 to hold those investments, or to hold the property and the trust investments, I think I've got the language right, and to apply them in a particular way as far as the trusts are concerned. And it's split into two, and I don't need to read it again. So what I say about that, together with the incidental powers that are provided to the trustees, is entirely consistent with it operating in the present as opposed to in futuro.
Well, it's contemplated it will operate very shortly. It doesn't appear to have operated according to its terms on any view, and there's no evidence, as far as one knows, I think, that the trustees have themselves done anything. But can I just ask you about clauses 3, 4? Clause 3 shows perfectly well that the draftsman understood the difference between bare legal title and beneficial ownership, and he said the settlor is the beneficial owner of all that property, etc., the trust property. Why should we construe Clause 4 as limited to the bare legal title, whereas sub silentio, you say that in some way or other the equitable title passes immediately? You may derive that possibly from what is said in Clause 5, simply to be a desire rather than a declaration. Isn't it all slightly odd, interpretation.
My Lord, can I try to answer my Lord's first comment, and I'll try to respond to my Lord's questions. So I'll try my best to do it together. My Lord, my respectful submission is that clauses 1, 2, 3, 4, and 5 are entirely consistent with a current transfer of the beneficial interest to the trustees. That's point number 1. So they're consistent with it. In other words, I'm trying to, as it were, meet the requirement of a sensible construction. I haven't gone to benevolent construction yet. Again, that's my fallback position. My primary position is that this is a Shah and Shah case. It's not a Choi Tram case, but I'll come to Choi Tram momentarily. So that's my first answer to my Lord. My Lord asked me on a couple of occasions.
That's if I may say so, that's more like an assertion, like a submission as to
well,
why
my Lord,
they're consistent. I was suggesting they don't look terribly consistent. I mean, if you take them together, 3 and 4, 4 is on the face of it referring to the same things as 3, in other words, embracing both legal and equitable title, and 5 is a mere desire.
Sorry, my Lord, can I continue what I had in my head? Which is to say that, my Lord, as my respectful submission as a matter of law, is that upon the transfer, yes, I accept that that's my argument, upon the transfer of the equitable title, the settlor holds the legal title on trust for the beneficiaries. So we say respectfully, and that's consistent with the authority.
Wait.
So, my Lord Hughes, can I say it again so that my Lord has it?
No, just pause for a moment.
I apologize.
The settlor. Now, you're now saying the settlor doesn't hold the legal title on trust for the trustee, but for the beneficiaries, so that the settlor is undertaking the duties of trustees under the deed.
No, my Lord, I'm not going that far. Because my Lord is putting to me a suggestion that I haven't made. I am simply saying that as a matter of law, the settlor holds the beneficial interest on trust. It's a bare trust, but that is the, how should I say, the position which applies in the interregnum between the current moment of the transfer of the beneficial interest, and my Lord Hughes knows where I'm going.
I think you mean on trust for the trustees.
Yes, my Lord. So what did I say? Did I say the...
You said for the beneficiaries.
My Lord, I apologize. My Lord knows what I apologize for that, my Lord.
It's a bare trust.
It's a bare trust.
For the trustees.
For the trustees.
Yes, I see.
Which exists in the interregnum between what we say respectfully is the current moment of the transfer of the beneficial interest.
And that you say is the only way you can give effect to the word immediately.
Absolutely, my Lord.
Right, well, I think we've got... Now, is there any authority which is particularly helpful to you?
My Lord, if I could ask my Lords to look at Mr. McGee's text, Snell, as a starting point. I think that should be found in the second volume of the authorities. Yes. Well, that's tab 36. I'm on page...
Sorry, tab?
1575. Sorry, tab 36, my Lord brings.
That's okay.
36. I'm on page 1575 of volume 2 of the authorities.
Thank you.
That's fine. As late as you like, start.
Yeah. 236, sorry, I'm with you.
So, tab 36, page 1575. 1575, my Lords. And it's paragraph 24008. And my Lords, my Lord answered me.
Yes.
My Lords, so I adopt the ipsissimo verba of the editors. If the transaction has proceeded to the point where the title of the donee is complete in equity, then the donor holds his retained legal interest on trust for the donee. My Lord, a reference of Rose is given, and I would like to take my Lords to Rose momentarily. And my Lords will see that this has followed a discussion of Rose. I just want to point it out to you because my Lord sees it on the opposite page, 1574. So we have Rose 1952, which is the Inland Revenue case, followed by a discussion of Pennington and Wayne, I apologize. And at the end of that section under unconscionability, my Lord sees a reference to Curtis and Pulbrook, which as I understand it is a decision of my Lord Justice Briggs as he then was. So, my Lord, I rely on these authorities because what these authorities demonstrate when I take you to them is they are authority for the proposition that the transfer or the assignment of the equitable interest can give rise to the very trust that I've simply been trying to argue for as opposed to assert.
Mr. Benjamin,
My Lord.
It was effective in Re Rose
Yes.
because the donor had done everything which he alone could
That's
do
right. Yes,
in
my Lord.
order to transfer the legal interest.
Yes, my Lord.
The present settlement contemplates that the legal interest will be passed to the trustees, but nothing has been done to do that.
Correct, my Lord.
So this is a new step has been taken in that direction.
That's right, my Lord.
So why should equity intervene in those circumstances?
Well, my Lord,
It would be perfecting an imperfect gift.
my Lord, with respect, my respectful submission is that it's not perfecting an imperfect gift. It is another means by which the transfer of the equitable estate can come about, as opposed to the perfection of the transfer of the legal estate. In other words, my Lord is correct. When my Lord invites my attention to Rose, that is what was being argued about. In other words, had all the steps been taken, had the share transfer forms been signed, had they been duly executed, and had they been handed over, and hence their lordships in Rose, I believe it was Lord Justice Jenkins and the then Master of the Rose Evershed, had to contend with and answer the question, had all that could be done, had been done in order to effect the transfer of shares, as opposed to real estate, for the purpose of making a determination as to whether or not the gift the trust was completely constituted. So what I say respectfully is applying the principle of Rose, of course, in a different set of circumstances, in other words, beneficial interest, in land. Can there be a transfer of beneficial interest? With respect, we say the answer is yes. If there is such, is there anything further to be done in order to complete or perfect the transfer of the beneficial interest? Answer no. Our respectful submission, therefore, for the i.e. only the beneficial interest, is it completely constituted? Is it a gift that needs another step to be perfected for the purpose of transferring the equitable interest? Answer no.
Well,
that is a distinct question.
It's slightly circular, all this, because
Yes.
you're assuming we can derive from this a clear intention to transfer a beneficial interest, to create a double, so to speak, level trust, firstly, in favour of the trustees, and then, at a later date, when the legal interest is transferred, well, I suppose that's actually mere form at that stage. Everything effective happens at the first stage, you say, and it raises the question why Recital 4 focuses on an irrelevant stage.
My Lord, with respect, my submission, right or wrong, is not what my Lord just put to me. My submission, with great respect, is exactly as set out in the passage I'm drawing your attention to. Can I go to the second sentence? The trust arises solely for giving effect to the intended transfer. So what that means, respectfully, my lords, is that it is therefore open to the trustees to call upon the settlor to effect the transfer of the legal title.
Well, is it?
Yes, my lord.
Begs the whole question, doesn't it? They can certainly call, if they've got the beneficial interest.
they can.
They can call, if they've got the beneficial interest.
Yes, my lord, absolutely.
Then, of course,
my lord,
they
you are
can
right.
call-
If they have the beneficial interest, then they can call for it. So what my lord already has my submission as to why I think my respectful submission is that the clauses, and I play emphasis on the operative parts of the deed, do have that effect, as opposed to the effect argued for by the other side, which is that it is completely contingent. It is to be dependent entirely upon what might happen with respect to the legal title. So we say with respect that our interpretation...
Look, forgive me. I know I don't do a lot of this sort of thing, but am I right that the beneficial interest passes under this deed?
Yes.
If, but only if, equity regards it as something which ought to be done and can be treated as if it has already been done?
No, my lord.
Not?
No,
Right.
no, my lord. My respectful submission is that the document has effect immediately,
In
and
creating an equitable interest.
in transferring an equitable interest, my lord.
Yes. Well, it doesn't say so, does it? It is the expressly, but you have to derive that from.
Absolutely, my lord. Yes.
I think we probably got the point. We are taking a considerable
Yes.
time on that point. You've got other points.
Yes, my lord. So, my lord, can I?
That isn't the same as saying next question.
Well, my lord, my lord, I'm not going to receive it in that tone at all. My lord, can I make a few observations in relation to the authorities without necessarily taking you to them in detail?
Well, you have to be very quick. Yeah, I think we will sit, assuming.
Well, I will do it whichever way.
Probably half an hour extra to 1:30. But
Well, look, could you give me an idea of how much time you?
We're not giving you until 1:30.
No, I know. You're not going to give me. No, my lord. Can you tell me positively how much time you are going to give me?
Yes, I mean you take another just over a quarter of an hour and try and adapt your submissions. We've got this point. You've given us very full references. We see what's said in Pennington and Wayne.
Yes.
Although that, according to Mr. McGee's book, may turn on reliance. And there's no evidence of that. It was an issue between. It was a rather special facts.
Yes.
But leave that aside. Where do we go, assuming we've got those on board?
Yes, my lord. So, my lord, can I say, my lord, my initial submission to my lord was that this is my primary submission. My lord, I think, is familiar with the authorities which say that in certain circumstances you can, by way of a benevolent construction, decide that there is a declaration of trust. Can I be forgiven for not taking to those authorities? Right. My little friends has set them out in detail. We have them in the bundle. We have summarized them. Yes. Can I just say one thing about Pennington and the Pennington case? My little friends have made a suggestion that it has been not well received. And so can I simply make the respectful submission that when one comes to look at the authority, look at the how should I say, the academic conversation, and not starting with and making the point that its reception by the judiciary is not, how should I say, to be found in the same tone or vein as the academic discussion.
So just identify for us the cases which you say give it a favourable.
Well, my lord, I would say that in fact all of the cases decided after 2002 have to consider the Pennington decision.
Has there been any appellate decisions since Pennington and Wayne?
My lord, I don't think so.
It's the first instance case.
Yes, I mean, there was a first instance judge sitting at the appellate level who might say something about it in this decision. But apart from that, my lord, it has been, how should I say, it has been applied by respected and competent chancery judges looking at what it did and what it could not do. And my second comment about it, my lord, is that the conversations and the discussions, the debate that took place between Madam Justice Arden on the one hand and Lord Justice Clark on the other really speaks to an attempt to deal with some of the strictures of the rule in Milburn and Lloyd, and they do so in what we respectfully would suggest is an innovative and helpful way. And that a close reading of the academic material reveals a more balanced reception than is suggested for my learned friend's written case.
So which is the academic material you'd like us to look at?
My lord, I would ask my lords to pay particular attention to Mr. McGee at tab 35, because he had a vested interest in, as it were, two things. Of course, he was counsel in the case. He was on the winning side. Please don't hold that against him. But I do regard his discussion in the article, Trust and All's Fair, as a balanced one, yep, and more balanced. Right. And my lord, if you go to any of the others, and it doesn't matter which of them you go to, you will respectfully see a balanced, I should say, assessment. And I would say a receptive assessment to the decision. Well, Lord, can I just leave that question alone now and move on to the next point in the time that's available to me?
Right.
My Lord, the next question has to do with registration. And my lords would have seen from our written case how we deal with registration. My learned friends rely upon section 16, and we say with the greatest respect that it does not take matters further, for precisely the reason that what we're talking about in this case is not someone who is a purchaser for value, nor a mortgagee without notice, and so on. Lord, those points are set out in my written case, and unless my Lord would like me to answer a specific question on it, I'd like to adopt what is set out there in the interest of time. My Lord...
Well, I only have one question, I think, for you, which is, taking on board everything you say about 16 and 17,
yes.
17 not in terms referring to a judgment creditor.
Yes.
What about the combination of 16 of the Registration of Deeds
Yes.
Act and 5 onwards of the Remedies of Creditors?
Yes, which has to do with the effects.
Which appear to constitute the judgment creditor as being in a good position as someone who's got an equitable charge under hand.
Yes.
So that it might be argued, and I'd like to have your response to this, that notwithstanding that Section 17 of the Deeds Act doesn't refer to judgment creditors, nonetheless the priority by reference to the date of registration provided for in the first part of Section 16 nonetheless does work for judgment creditors for that reason.
Well, my Lords...
Not quite how the Court of Appeal put it, I fully accept.
Yes.
But I'd like your...
But you wouldn't... But, so, my Lord, my respectful submission is that the preferred construction of the Registration of Deeds Act is to treat the language as providing, as it were, a complete code as to how these issues of priority are to be discussed, and to the extent to which the draftsman has not made a specific positive position, we would say that my Lord's, how should I say, thoughtful suggestion that one needs to read Section 16 in light of Sections 5, I think it's 5, 6, and 7, my Lords,
yes,
invited my attention to, of the Remedies of Creditors Act, does not answer the question about priorities.
Well, and 8, actually.
And 8, yes. It doesn't answer a question about priorities, respectfully. What it does is limited to telling you what the impact or the effect, if I can put it more accurately, of the registered judgment is. That is to say that it constitutes a charge and that it should be dealt with in a particular way. My Lord, I hope that's a helpful, well,
thank you.
That's the best that I can do in light of my Lord's question. My Lords, can I invite my Lords, in light of my Lord's mention of the Remedies of Creditors Act, to look at some of the sections which will enable me to discuss the next point. And my Lords will recall that in our written case, we set out a number of provisions and we set out a little bit of history. So, my Lord, can I just invite my Lord's attention to a couple of those provisions which provide, we say, a code that provides and ensures or seeks to ensure, and this is my axiomatic point, it seeks to ensure fairness between the judgment debtor on the one hand and the judgment creditor on the other. And we say that that point is made good by reference to the following provisions, and these are just by way of illustration, and I'll come back to them. So sections 37 and 38, in general, provide a process whereby the court is mandated to investigate the nature of the beneficial interest, as well as make specific provision for the precise conditions and conditionalities upon which whatever the beneficial interest is that is identified, and in whomever the beneficial interest resides, how that beneficial interest is to be sold or disposed of. That's section 38, and it follows from section 37, but it's also section 39. My Lords, I'm on page 1022 of the authorities bundle. Again, my Lords, in the interest of time, can I also invite my Lord's attention, consistent with that primary submission, to section 47 of the Remedies of Creditors Act, which provides the basis upon which, or the circumstances in which, the court, again, is empowered, provided one or other of the four conditions are met, that, and this is important, to direct that, and I'm on page 101026, to direct that an attorney at law or conveyancer to be named by the judge not being concerned as an attorney at law, the summons shall report to him. So that, in effect, what this statute is doing is providing for an independent, impartial, arm's-length expert to provide the court with assistance in the circumstances that arise under 47. And I say that is entirely consistent with my primary submission, that the overarching objective of these provisions is, again, to ensure fairness between the judgment creditor on the one hand and judgment debtor on the other hand. And then finally, again, by way of illustration, can I invite to my Lord's attention to section 54? My Lords will see that my learned friends and I, on the other side, have had a debate as to what this means. And my friends say that 54 is to be read in a particular way. That is to say, it only comes into effect, that is, i.e., the power on the part of the judge on the return of the summons to order that execution of sale or by sale can be stayed only if the judge is going to go on to appoint a receiver. So what we say respectfully is that is how shall I say, a narrow reading of the section, and that what the section expressly contemplates, first of all, is for the judge to consider whether or not it is desirable that the ascertained beneficial interest should be sold at all. And what we say with respect is that even if Parliament hadn't put those words there, that the judge would be under a statutory obligation to consider or not whether he should order a sale in any event. And we say that that follows from section 37 and 38. Or to put my submission in another way, let us assume that the Remedies of Creditors Act did not contain section 54. Our respectful submission would be that the judge would have to ask he or she would have to ask themselves the question, is it desirable, appropriate to order the sale of this property? And once you ask that question, my lord, and as far as the question...
Well, wait a minute. You don't get that easily out of sections 37 and 38 by themselves. You're now on section 54 primarily.
Yes, my lord, I am.
And you're now asserting that 37 and 38 do the trick, but I wonder. I mean, 38 is in mandatory terms. On your case, 54 is sufficient, provided you read it disjunctively.
Yes, my lord. So that, again, that's my primary submission. My fallback submission is that when you read the whole of the statute, and that's perhaps a better or a different way of putting the very same submission, one reads the whole of the statute, including section 54, my respectful submission is that the discretion exists to determine whether the beneficial interest should be sold. And once one accepts that the court has to decide or determine whether the beneficial interest should be sold, we say it follows inexorably from that the court also has a discretion to determine when the beneficial interest should be sold. So that it's not simply a question of saying there should be a stay. It could be a set of circumstances in respect of which the court decides that the summons for sale should be adjourned, obviously on a proper basis. It could be a circumstance in which the court decides, I wish to make an order for the sale of property, but on the facts of this case, if there is going to be a sale, then that the sale of Hebron Heights should precede the sale of Victoria Square. And I go further in light of my lords, if I may say so, perfectly fair questions to be about saleability and interest and et cetera, and the like. We would say respectfully that putting all of that to one side, that what ought to happen, and we say this is mandated by these provisions, is that a fair opportunity for the sale of that property by the one person who has the power to sell it without recourse to anybody else, that is to say the respondent, and to do so entirely free of any other interest, such as depositors, repayments, any other sums outstanding, without regard to any other cause upon the proceeds of sale. We say that that follows from our respectful submission as to what the proper effective construction of the Remedies of Creditors Act is. Now, my lord, it is said against us that sections 37 and 38 are quote-unquote mandatory. So what we say in answer to that is as follows. We say that just like any other statutory discretion, the judge is bound to have regard to relevant considerations, and the argument...
They're not discretionary. It said they're mandatory.
Yeah, my Lord, yes, I'm going to come to that. So, my Lord, they say it's mandatory, but my submission is a little bit different. My respectful submission is that the judge is bound to have regard to any relevant considerations that arise from the factual matrix, so that, and just choosing two which are at play in this case, one has to do with timing, the time at which sale should take place. Two has to do with conditions, and three has to do with reserve price. So our respectful submission is that any and all of the facts that are pertinent to any of those criteria, the court is bound to have regard to them and to give them their appropriate weight. What happened in this case was that the lineage judge at first instance decided he had no discretion whatsoever. The Court of Appeal contradicted him. We say respectfully that they were wrong. And they said that, in fact, he did have regard to those considerations and decided not to exercise his discretion. And my Lord has our written case where we try to gainsay that argument. So that my respectful submission really flows from the statutory construction and the requirement that the judge is in no different position from any other individual.
But does the discretion arise under sections 37 and 38, or does it only arise under section 54? And if it arises under section 54, must it be, if it's exercised, accompanied by some form of equitable execution or appointment of a receiver?
My Lord, my respectful answer to that is that the discretion arises on the basis of each of those sections, and that the proper way to approach it is not to take them in isolation.
Yes.
That is actually not consistent with good statutory construction. That if you want to answer the question, what is the nature of the discretion, or what discretion does the judge have under the Remedies of Creditors Act, one would have regard to all of the sections, and one would have regard to, and I tried to give you some illustrations of those sections where what Parliament is trying to do, while respecting the fact that the judgment creditor is seeking to recover, these are all protections for both parties.
I suppose as a fallback, at the very last resort, if it only arises under 54,
yes,
then the judge could here have appointed a receiver to at least ensure that the judgment creditor was getting something out of the property. I think your client would have resisted that on the basis she needs the proceeds of the rent and so on from Victoria Place. But that's a different matter.
Well, my Lord, that is a different matter. And again, I don't want to breach any prohibitions about evidence, but the situation has changed.
Right, well...
My Lord, can I now go to, I don't know where I am, because I have said nothing about valuations, and well, Lord, you tell me.
Well, we gave you till quarter to. What is it? I thought you dealt with everything.
Well, I dealt with discretion.
What do you say about valuations? You've already said.
It's the reserve, is it? Is that the point?
It's both. It is. Well, my Lord, can I just put the general proposition, and my Lords will tell me if I can have another minute or two. So, my Lord, can I take it in reverse order in terms of the 5 points that I said in the written case? As far as the reserve price for Victoria Square is concerned, my little friends on the other side don't treat with the fact that the valuator upon whom they relied did not conduct a complete inspection of the property. And he says so on the face of his valuation report. He says, I stood effectively, and I'm paraphrasing, not giving evidence, I stood in the reception area and I took a glance and I came to a particular view.
Okay, right,
so we would say that's not a basis upon which anyone...
No, we've got that.
Right.
You've got to take these
And then
points.
secondly, my Lord, as far as the valuation of Heaven Heights is concerned, can I just ask my Lords to look back at my friend's written case, and my Lords will see that what they do there, and the documents are to be found elsewhere, but it's helpful to look at their written case. And my Lords, I apologize. My Lord will recall, you will see there the affidavit of the 23rd of June 2014. I was struggling to find it in the record, but here it is. Are my Lords with me? So my Lord, as an annexure to their written case, my Lords will see that there were next various documents.
Yes.
And there are just two documents I'd like to invite my Lord's attention to. does my Lord first of all have, for the purpose of my valuation point, towards the back, the various valuations provided over a period of time, starting in September of 2007 and coming forward to 2009, I believe.
Yes.
Do my lords have that? My lord, this is an annex here to the affidavit of
Yes,
Mr.
well, we've got various valuations.
Yes, so my lord,
LR.
can you look at the very first one? I have a small point to make on it.
Yes. Well, I think you've got to take big points, not small points.
Yes.
At this stage, right? LR1, yes?
Yes, LR1, my lord will see that there's a valuation there for $17 million.
Yes.
That's at page 7.
Sorry, it isn't page 7.
Sorry, well,
67.
67.
Yeah. Right.
Sorry, I'm reading the page number on the
Yes.
very top. So does my lord see $17 million and $80 million
Yes.
below that?
Yes.
So my lords, in the affidavit itself, where Mrs. Deslauriers says at paragraph 39 that she's guesstimating, I'm on page 62, she's guesstimating that a sale of Heaven Heights would fetch about $20 million. It is seen in that it is against that context, so that it's not a point to be taken against her. She is expressing an opinion based on LD2.
Okay.
And my lord, can I invite my lord's attention to the next document, which is the quantum cost management document, page 68. I trust my lords have it.
That's how much has been invested.
That's how much has been invested. So my lords will see that this quantity surveyor's assessment, that $46 million, and I just want to pause there, my lord, to simply state the figure, that $46 million had been spent on the project.
Yes, we've got that.
And that this is the basis for the valuations that come afterwards, all the way up to the valuation of $77 million. My lords will recall that in our written case, in error, we suggested that the work had continued until April 2014. And my learned friends very helpfully suggested that obviously is not right. So that, my lord, this is the, how should I say, the most contemporaneous document, which reflects the amount of work that had been expended on the property.
Yes.
And my lord, we say it follows from that the values, the value of the works in situ together with the property would necessarily exceed $46 million.
It doesn't follow at all, does it? I mean, you can pour a huge amount of money into an incomplete building.
Absolutely, my lord.
And if you leave it then to stand for about 8 years, it can lose value very rapidly.
My lord, I'm not gainsaying that. I'm simply relying upon the document as to what it says at the time.
I see. So the subsequent values are all on that basis?
Yes, my lord.
Right.
But my lord, can I just assist my lord in answer to my lord's last comment? That, my lord, I don't upset my lord. My lord.
You're not upsetting me, but I really think that you must draw it to a close.
Yes, my lord. I promise this is the last sentence. My lord, the state of the property, the evidence in this case is that Mrs. Deslauriers has been using the proceeds of the rent to maintain and secure the property. So that, and there is no evidence, if I may say so with respect, although it's a perfectly logical speculation going the other way, that the property must have deteriorated over time. But what the evidence, in fact, is the other way, that steps have been taken to maintain the value of the security for the purpose of enabling the respondent to realize as good a price as they can get, because there's no incentive for her to do otherwise. My lord, I'm sorry for going over time.
No, thank you very much indeed. Are there any questions?
Yeah.
We go out and see where we are. I think we'll retire for a moment, just see where we are. Mr. Keeley, we're going to leave Victoria Square at least until tomorrow. We'd like you now, if you would. We've had a very full case from you on the main appeal. You've heard the arguments, you've heard the points we put, and so it's probably unnecessary to go into your case in the detail in which it's written, but would you like just to give us the skeleton outline of your reply on the various points as shortly as you can?
Absolutely. Well, I'll leave aside then my argumentum ad misericordiam with which I was going to start.
Quite. No, I think we understand that sort of point from not just from a bank, but
and I'll take it as read.
Any other financial institution.
Not a bank.
Yes, right. I see.
My Lord, I can take this quite shortly. It's quite clear from the emails that were open to you this morning by my learned friend Mr. Knox, that the discussions about additional financing, insofar as they ever took place, before the loan was granted in September, October 2007, were confined to the specific loan transaction which was being sought and which was ultimately agreed. And it was agreed as a discrete loan of 18.6 million Trinidadian dollars, repayable by one bullet repayment in 18 months' time, with interest payable quarterly. Whatever Mrs. Deslauriers might have thought or now say, it was entirely reasonable for GAM, my client, and particularly Mr. Ramsden, to believe that those discussions and to understand that those discussions about possible additional financing, insofar as one can actually extract them from the emails, were so circumscribed. In fact, one or more of your lordships have queried the interpretation put on these limited communications by Mr. Knox this morning, and that, if anything, simply demonstrates that one reasonable interpretation of those emails was that, insofar as ever additional financing was spoken to, it was concerned with the discrete loan and the amount of the discrete loan that was to be advanced and extended. I won't go through the emails again, but your lordships will remember we started off with about 15.5 million, we ended up at 18.6. And it's in that context that those emails need to be considered and analysed. Even if one were generous to Mrs. Deslauriers in relation to those emails, what they comprised were what were apparently passing remarks. If they were intended to convey a wish to borrow more in the future, then this was a matter of such significance, if it was a matter of such significance to Mrs. Deslauriers, that she needed to know whether she could borrow anything more in the future, such that she was actually placing reliance on a real possibility, if not a probability, of future funding in deciding whether or not to take out the loan with GAM, then it was, as a matter of fairness to GAM, as a matter of common sense, incumbent on her to say so to GAM and to seek assurance from GAM, either that GAM would provide such funding, or at the very least, that GAM was prepared to provide such funding. What is ironic about the Deslauriers case in relation to this is that the whole basis of the trial before Mr. Justice Rahim was that GAM did, in fact, promise to provide funding for the entire project up to $60 million if such funding was required.
Was there a reference for that, up to 60 million?
60 million, yes. If I can...
I know the value of the project was put at 60 million, but is there a reference for the to that being the actual case, that the whole 60 million or the whole of the balance might be?
Yes, if your lordship goes, for example, to page... I'm probably going to take you... I was going to take you to quite a few documents, but I'm conscious that you might not welcome that. But, for example, if your lordship goes to bundle 1, page 409, it's probably not the reference I really want to take you to.
Give us just references to look at if you want to.
Yes, well, I think I should. Rather than do it that way, can I... well, yes, 409.
Right.
409. This is, in fact, the cross-examination of Mrs. Deslauriers by my learned predecessor. And at the foot of the page, two questions are.
Oh, yes.
There was also no agreement for GAM to finance the project to a tune of $60 million. Isn't that correct? The answer was, by oral agreements, not reflected anywhere in the correspondence. Answer, not in the beginning. And then if you look at the right-hand side, 411, the top, and I'm just choosing some potted extracts, my lord. The first question, are you now accepting, having read the record, that there's nothing in writing talking about any agreement promised or undertaken on the part of GAM to lend you $60 million? Answer, on the part of Mr. Ramdeen or GAM, yes, there is not. The case was, my lord, and I was going to take you, I can give you the references, I was going to take you in slightly more detail. The case was, my lord, that my clients not only extended a discreet loan on the terms of the promissory notes, but also promised, undertook, and represented that they would provide the entire financing for the project up to, if not exceeding, $60 million. And the reason why I emphasize that, my lord, and that was just one little, as it were, snippet from the evidence. The reason why that is so important is because that was the primary case before Mr. Justice Rahim. That colours the entire misrepresentation case that was made against my client. The reason why it was alleged that the lending limitation, let's assume there was one, was relevant was because of the promise to provide vastly in excess of the alleged lending limitation. The misrepresentation case was indeed pleaded, as Mr. Knox says, but it was entirely derivative of the central plank of the case, which was that off the record, and I emphasize off the record, Mr. Ramdeen had promised to fund the entire construction project.
I'm just wondering, Mr. Keeley, if the 60 million was as deployed, at least in the cross-examination of Mrs. Deslauriers, was an advocate's jury point. Had the figure arisen only in the course of the trial?
Yes, it had, in fact, Michael.
Unless it's there earlier.
No, it is there earlier. I was going... The trouble is...
Just tomorrow, give us the reference.
Page 169.
Okay, done.
In fact, we might as well have a quick look at that. This leads actually, my lord, into where I wanted to start, as it were, which page 169 of Bundle 1 in the main appeal.
This is the protest.
Yes. Second paragraph. During the several meetings that we had discussing aspects of the development, not one time was it ever mentioned as you pursued taking on a $60 million project, etc. And that's just one example. But it's a very important example, because as your lordship will see, there's a reference to GAM having taken on a $60 million project. The whole gravamen of the case against my client before Mr. Justice Rahim was that we had taken on the business of financing the entire project. We had done so by extending a discrete loan, and we had, off the record, promised to go all the way up to 60 million, if not beyond, for the purposes of completing the project. Mr. Justice Rahim expressly disbelieved Mrs. Deslauriers' evidence. That there had been any such promise, and that any such promise or representation had been made off the record. Can I just give your Lordship an example? Page 439 of the electronic bundle. Paragraph 63.
Yep.
Much scrutiny, communications. The court found that there was indeed nothing said or done on the part of Mr. Ramdeen which amounted to a representation, either expressed or implied, that the claimant would finance the project. For reasons set out hereafter, the court does not believe the second defendant when she testified in cross-examination that Mr. Ramdeen made these representations off the record.
And in the next paragraph, dealing with the conversations which you've already dealt with, the emails.
Exactly.
In no way could the several conversations between the parties have been interpreted so as to saddle the claimant with the representation in relation to the financing of the balance of the project.
Yes, that's exactly right. And reference is made by the judge, I don't think really terribly rudely, he refers to her unconventional method of expressing herself in the relevant correspondence. As a matter of common usage of language, etc.
Yeah.
If your Lordship can go back to where I, as it were, wanted to start, there are three important findings by the learned judge which undermine the Deslauriers case at trial, quite irrespective of all the other insurmountable difficulties by which they were faced. Firstly, the finding that we've just discussed, that GAM never promised to provide Deslauriers with the funding required to complete the project. Secondly, that we've just discussed, and the references are 433, 434, 435. Secondly, the related finding that Mr. Ramdeen never represented or held out that GAM would finance the project, references 439, 441, which was related. There was never, as indeed the judge says at 430, there was no understanding that there was to be a long-term relationship. And thirdly, the finding to which Mr. Knox took your Lordships, that Mr. Ramdeen was told by Mrs. Deslauriers that it was her intention that the balance of the project was being funded through other means, that additional funding was being sourced elsewhere, and Mr. Ramdeen believed what he was being told. And that's an important finding, as important as the others. Because as we've said in our case, my lord, Mr. Ramdeen was actually put off notice rather than put on notice that Mrs. Deslauriers would be back or might be back for further funding in 18 months' time or 12 months' time. He was put off notice that she would be back and saying, could I please have an extra $41.5 million odd dollars?
Have you given us the reference for that third?
This is, my lord, pages 79, the witness statement of Mr. Ramdeen that you saw, which in our respectful submission makes it entirely clear that the time when these discussions took place was at the beginning in June 2007.
Paragraph 6, G and H,
Then you want to have a look at 253, which is a document you haven't looked at yet.
Sorry.
253, my lord. If you just bring it up, terribly quick point.
Last paragraph.
Exactly. Last paragraph, first four lines. 355, which was taken to your lordship, Mrs. Deslauriers didn't say that she didn't tell Mr. Ramdeen that she was intending to source the financing elsewhere. Rather, she asked him when she said it, and he answered that he didn't know the exact date, time, and hour, which is probably not surprising.
This is a litigant in person. Come on. When did I say that?
Oh, yes.
Means I didn't.
That may well be right, my lord. That may well be right. But anyway, it was put to him, and what he didn't say in return was, "It's a fair cop."
No.
Right.
Now that I'm confronted you by Mrs. Deslauriers again, I submit. You've also got page 429, which is part of the judgment, at paragraph 39, which is a finding of primary fact on the basis of primary evidence. Not a question of inference. It's paragraph 39. And you also have page 434, where at the bottom of paragraph 51, the last sentence, additionally, this is particularly new, is so since the court had accepted the evidence of Mr. Ramdeen that it was represented to him specifically additional funding was being sought as well. Now, a criticism has been made of that conclusion because it said that Mr. Ramdeen in his evidence had said it was, he was told that Mrs. Deslauriers' intention, but we all know what it means, my lords. I don't think we can pick at this as though it were a statute. And I think I've taken your lordship to 409, where the $60 million figure. So if we can just go on, I'm going to take you very quickly to the documents just to make good this, because as soon as the main case, which my learned friend has described as a dead duck, well, at the time of the trial, it was a very animated duck. And it had to be shot several times before it was finally dead. But having killed that duck, the duckling, which pursued it, also died necessarily because its mother or father, as the case may be, had disappeared. In other words, the case of funding the entire project emasculated the case on misrepresentation. And in order to understand that, my lords, you have to go firstly, and I'm going to go through this very quickly, so you can rest assured. I may bore you, but I'll bore you very quickly. If you go to page 41, this is the defence to paragraph 3.
Sorry, page
41, my lord.
Page 41, thank you.
This is the defence at paragraph 3. Last 3 lines. The claimant's representative aggressively pursuing the defendants to allow the claimant to finance the said Hebron Heights development and making certain representations to the defendants. My lord, that is not to extend a loan of 18.6 million. That is to finance the entire development. And this is the theme that goes all the way through the Deslauriers allegations. It is alleged consistently, persistently, and untruthfully that my clients pursued them in order to finance the entire construction, including finishing, and it was in that context that the representation was made. I should mention, my lord, for your reference, page 433, paragraph 50, subparagraph 1, the learned judge says that there was nothing in the correspondence to suggest that the defendants were induced or aggressively pursued by the claimant for the financing of the project. By implication, that allegation was dismissed. And at page 42, my lord, you have it again at paragraph 12. Here, it is suggested that we ask to be permitted to finance the defendant's development. And that is just false. If your lordship turns to electronic bundle page 86, a document that my learned friend took your lordships to, your lordship will see the breakdown of the figures from Republic. The loan, my lord, was actually to discharge the Deslauriers' debt to the Republic Bank, which had been incurred in relation to Victoria Square, which is another of Mrs. Deslauriers' developments. She says that her family has lived there for hundreds of years, but actually, apart from the top floor, it's all rented out, or was all rented out as commercial premises, and she did it all up, and that's the cost. And secondly, a teeny-weeny bit of Heveron Heights. I should mention, my lords, just en passant, that Mrs. Deslauriers had spent 21 years prior to this developing properties in Texas and in Trinidad. She was not an inexperienced property developer. Reference 391399. She owns, or did own, 5 apartments in Goodwood Park, of which 3 were rented out to third parties, and 2 were occupied by her family. Victoria Square, Appeal Main Bundle 129. Before your lordship thinks that I've been harsh on Mrs. Deslauriers and her cross-examination skills, can I just inform your lordships that the hearing before Mr. Justice Rahim took place on the 28th July 2011. On the 27th of July 2011, one day before, she was represented by 3 counsel, including senior counsel, in the Trinidadian Court of Appeal. Douglas Mendes, SC, was the senior counsel. So she wasn't short of legal support when she wanted it. Indeed, today, she's not that short of legal support because she thinks she wants it. Nor in the Court of Appeal. She was assisted in her closing written submissions by David West of Counsel. Page 460. She has been, I don't know whether it is completed, she has been engaged in fraud allegations and litigation against the Republic Bank and her own half-brother since 2002.
Well, I think we've got the general point, but we seem to be straying rather a long way from the actual
This is
issue.
not part of my plea in misericordia. This is just to explain to you.
Your basic...
Sounds a bit like evidence, Mr. Kennedy.
Right. Your basic point is that she is, which is evidence, is that she's quite an experienced...
She knows what she's doing.
...woman, a businesswoman, and so on.
Well, she knows what she's doing. She's got legal assistance.
Yeah.
Think about the Victoria Square appeal for a second. That deed of settlement was prepared by her legal representatives,
yeah.
And they know what they're doing. And they also prepared, this is en passant as it were, they prepared the same deed of settlement, which was considered by Mr. Justice Aboud. That was the case that your lordship was looking for.
Yes, quite.
In Trinidad, which is where we cite quite a lot of the judgment in our written case on the Victoria Square. Where Mr. Justice Aboud looks at exactly the same clauses with one slight adaptation. In fact, the clause there was stronger than the clause in our case, because recital 5, which was recital 4 in that case, actually said also that it was irrevocable.
Yes, I see.
So,
Right, well, we're now straying on to...
You are, my lord, but you won't
territory.
forget all these things.
Have you...
No, I haven't.
Have you got any more you want?
I have got a lot more.
Well, you've got a very short time to say
I
it.
will say it very quickly. Right, okay, I'll say it extremely quickly.
Yeah.
Let me say it as quickly as I can, anyway. I'm going to jump quite a lot. If your lordship goes to page 46 of the bundle, oh, sorry, go back to 44, paragraph 19, my lord. Claimant's conduct is consistent with that of financier providing financing for a development project to its completion.
Yes.
Paragraph 34. In these premises, that's all the premises that we've seen. That's at page 46, my lord. Paragraph 36 on page 47, my lord. Giving a false impression that the claimant could have possibly granted the additional funding to the defendant's project. But that, my lord, is all in the context of what has gone before, and moreover, the immediate neighbour succeeding is paragraph 37. The claimant, in breach of their agreement, failed to provide the funding for the entire project. If your lordships go, please, to page 167. This is the top of the page from Mrs. Deslauriers, April 6, 2009. My learned friend read it, I think. Fourth line, in future, letting your customers know that GAM limitations in funding is crucial when taking on a project that is double the lending capacity of the company. Page 170. Well, you've had 169. And page 170, middle of the page, just after bold, where we should have been informed. What is more astounding is that in light of that fact, you would take on a project of this size, lending us approximately 30% of the construction and not expect to hear from us again before completion. Then if your lordship goes on to 176, first paragraph, last sentence, nothing was ever mentioned about a limited lending portfolio or the fact that you were taking on a project. Reply 182.
But where was that on page 176?
It's just after the first paragraph where the capital letter...
Oh, yes, I see. Yes, thank you. Yeah.
Sorry, where's the reply?
The reply, my lord, is, I think, sorry, forgive me. It's at page 182, I think.
82, thank you.
Yes. Second paragraph, there'd been no discussion with you regarding future financing, nor was there any intimation, that you'd be seeking further financing from us for the project. Never any discussion or agreement pertaining to this company's commitment to seeing the Hebron Heights development through to completion. First time you approached this company for further financing in December 2008, I indicated to you that that request was unlikely to be granted, etc. The issue at hand is not about the company's lending portfolio, but rather relates to non-payment of your indebtedness, etc. We didn't go any more with that, my lord. And then you want to go to, if I may, to 167. No, we've done that. To 250.
Yeah. Project of this size, yeah.
Yes. Project of this size, exactly. And look at the right-hand page, my lord. At the first break, about a third of the way down, we still have the US financing in progress. Feel it's your responsibility to see us to that point. Whether it's 30 or 60 days away, we need the 10 million in order our finishes, etc. and then towards the foot of the page, it's copied, my lord, to Mrs. Deslauriers' counsel. Does your lordship see that?
Yes.
About 5 lines up. If you do not fulfil your obligations to see us over this period as the financier of the project by your choice, as you sought the business for months, we didn't come to you, and we have no choice but to take this to another level to protect the interests of our purchasers, etc.
Yeah.
If your lordships could go to 282. This, my lord, is it's not my learned friend, but it is Mrs. Deslauriers' closing submissions before Mr. Justice Rahim. Paragraph 35.
Yeah.
Ramdean's failure to understand the process of financing a construction job. Paragraph 38, page 283. It should have been obvious to Ramdean, I think that must have been Mr. Ramdean, that additional finance would be needed to finish the construction. It's contended Ramdean didn't exercise due care and skill. Page 287, my lord. First sentence of paragraph 51. Held out to the defendants that GAM would provide the additional finance. And then paragraph 52 is important. The Deslauriers, based on statements made by Mr. Ramdean and Mr. Saint-Cyr, were quite at ease with moving to GAM, etc. But what is the context of that, I ask rhetorically? The context is that we had agreed to finance the entire project.
Yeah.
Page 289, my lord. That's not really terribly good.
Well, I think we've probably got this particular point, haven't we?
I can send you a list of the other pages.
No, I mean, you've given us...
So-
what about other aspects of the case?
The other aspects of the case.
I mean,
Right. Well,
one gets to that point, but assuming you were wrong on all that, there is the question of reliance and causation, isn't there?
if I'm wrong on all that, but right, I'm going to make some very quick points. The representation. Now, you've got our submissions in our case, but what we ask you to do is have a quick look, if you would, at paragraphs 52 and following as to what the representation was. This is in our written case, my lord.
Yeah.
And the reason I say that is because you have to look and see what is actually alleged against us by Mr. and Mrs. Deslauriers. And what you will find is that, perfectly appropriately, what is alleged against us, if you actually read the allegations correctly, is that the alleged misrepresentation or representation was that there were no relevant restrictions or there were no relevant differences or there weren't any differences of significance. So if you look at paragraph 53, according to the notice of appeal, the alleged statement, and you've got the reference there, the only difference between GAM and a bank was that the proposed loan couldn't be paid off, thereby falsely suggesting that, like a bank, it had no relevant restrictions. And we pay attention to that. In the context, my lord, that is substantially true, if not totally true. Why? Because the context was a loan of $18.6 million. Similarly, you see paragraph 58.
Yes, it comes back to the question, basic question, whether there was anything sufficiently serious being said about further lending
Yes.
to make anything that was said about their nature or capacity relevant.
Now, I take your lordship to a decision of Lord Justice Ricks in Avon, I think it is.
I think you've cited it in your case, haven't you?
I've cited it in my case. If you don't want me to, I certainly shan't.
Can you just take it from your case, perhaps?
Let me just have a look. Actually, it's better if we have a look at the case, at the authority itself. If your lordship could go to the authorities at divider 7. At page 1202. Well, can I invite your lordships, rather than, if your lordships could, in due course, read paragraph 14 through to the end of 18. And what you will find is a subsidiary factor which supports or encourages the taking of a decision and might be a cause for disappointment does not affect the essential validity of the decision, in the sense that it is not an actionable inducement. In order to be an inducement, my lord, it has to be sufficiently important to be called a real and substantial part of what induced the person to enter into the transaction. So I may go to a bank and say, can I please borrow £5 million for my rather smart house? And I'll be back probably in about 10 years when I've had my 3 children, and I might need a bigger house. And the bank manager says, not a problem, we'll see you in 10 years' time.
Yes.
Now, that encourages me to go to whichever bank it is, because he's so charming. But that doesn't actually induce me to go to the bank when I want a loan of £5 million for my very expensive house. That simply gives me a warm,
You're just
comforting...
disappointed when 5 years later he says, sorry, I'm afraid, actually, I've looked at it now and our lending capacity...
the market has gone down, or whatever it happens to be, or our lending capacity is reduced.
It's more like a puff.
It is more like a puff.
Yeah.
Exactly.
Right.
My case, starts from the proposition, as you know, there was nothing to put us on notice that anything that we said to them about the differences between us and a bank or a major bank, etc., was of any relevance at all. For the Misrepresentation Act, there has to be an intention to induce. I should have mentioned that. Sorry, I'm galloping a bit. There was no intention to induce in those circumstances where the relevant statement, which is alleged to have been made, was never intended to induce them to enter into the contract, because it wasn't considered to be a relevant factor.
Well, intention must be judged objectively, mustn't it?
That's exactly, as it were, the point I'm making.
Yeah.
Yes, it is. And so must materiality. In other words, a representation which is material is one which is likely to induce a reasonable person. If it's not material, because it is not likely to induce a reasonable person, then there is no presumption that it is actually inducing as a matter of fact. If it's not supported, therefore, with a presumption, then the burden lies firmly and squarely upon the representee, or alleged representee, to say that he or she was actually induced. But equally, if it is not a representation which is influential to a reasonable person, then there will be no duty of care imposed upon the representor, because in those circumstances it would not be appropriate to find that he has assumed a responsibility in relation to something which will not be, as it were, inducive to a reasonable person.
Now you're sagging from the Misrepresentation Act into a duty of care.
Into a duty of care.
They're different, aren't they?
They are different. They are different.
So,
But they
can I
share.
just ask, in passing,
Yes.
do you agree or not that the case in both the Misrepresentation Act and the tortious duty is there on the pleadings? Whether it was run at the trial or not is a different question. But do you agree it's there on the pleadings, or do you not?
I accept that nominally you might be able to locate it.
I see.
But I think that when you're considering a trial of a matter, you have to identify what the essential components of the case alleged are. And just because something is open on the pleadings,
say what really matters, as appellate judges are constantly apt to say, is how the trial actually ran.
I would say that, my lord. I mean, you can have something on the pleading which isn't advanced at all, and then pop up in the Court of Appeal like Mr. Knox, I didn't mean that rudely, and say, look, there it is.
What do you say about, you just touched a moment ago, you said the onus is on a representee to say that he or she was actually induced. I mean, you say in this case that there simply isn't that evidence that it had any effect either, really, in causing them to... I suppose that... is it a but-for test? But for the representation, would they have gone somewhere else? It's not, is it? You can be liable even without establishing the but-for test, can't you? They don't have to show...
They would have to say that they made the loan transaction with us and didn't go somewhere else.
They do have to say that.
They do have to say that, yes.
But they don't have to say that they would necessarily have gone somewhere else, do they? They just have to say that one of the things that induced them to come to you was X.
Yes, I think that's probably fair.
But on loss, don't they?
That's a different one.
Yeah.
That I'm doing.
On loss, they then have to show that they would, because it's their own conduct, probably gone somewhere else, and then presumably, Mr. Knox is right, that the test would be whether someone else, the chance of someone else lending them money, is it?
Well, yes, I mean, the loss of a chance, my lord, which is just, sort of, as it were, popped up,
yes.
like a puppet, is certainly something that one could think about if one had creative thinking.
It simply wasn't investigated at all.
No, well, of course it wasn't, because the whole case was not that we lost this chance, it was that you promised. Yeah. So, just going back to what I said to my Lord Hughes, I mean, you've just got to look at the trial. You can't have the allegations lying around in pleadings and then saying, oh, well, now that I've lost on my main case, I think I can, the word was in our case, to conjure up something new. And
except, I suppose, perhaps, that when you've got a litigant in person with professionally drafted pleadings behind her, never mind that she may even be a litigant in person by choice, it does happen sometimes, but you've got somebody with a case there. She's running a point which is going to fail. Are you under a duty to look at the other part of her case that she ought to have been running?
No, I have no duty at all, my lord. She put all her eggs in the basket that we had promised to provide this project.
Okay.
If she wanted to run a secondary case, which was, if contrary to my oral evidence, and I am disbelieved.
Because it's a matter of evidence, not of argument.
Yes.
I see.
I mean, exactly.
Yeah.
I mean, it's rather like the Filiatra legacy. You can't run a case which is actually there and then say, oh, by the way, I'm now going to traduce myself and say, I'm a liar. Please ignore my evidence. Now let's look at what I can argue, assuming that you disbelieve me on what I'm actually primarily telling you was the position.
Yes, I follow.
Right, well, Mr. Keeley, I don't know whether there's more you want to say at this stage, but I think whether there is or not, we probably ought to adjourn.
Yes.
Have you more or less covered the ground, in fact?
Depends how much ground you want me to cover. I'm sorry to throw it back.
I asked you to give us an outline.
It is an outline,
of your case on all the points.
If there are any other points, they will be staccato bullet points first thing in the morning, just so that you don't ignore anything that I might have said but failed to say. Otherwise, it's all in our case, actually, my lord, I have to tell you.
Well, that's why we thought that it was probably unnecessary to develop it further, because we have read the cases closely.
And also the Victoria Square is all in my case with one or two slight
Well,
additions.
we're going to need you to help us orally on Victoria Square. But
Good.
Yeah. Again, probably the case is a very good foundation and will help you be short.